Hey Gators, it's Dr. Jensen, and I thought I would post a quick video that discusses some of the challenges of doing research in terrorism. So I recently scored your design a study assignments, and I can tell you put a lot of effort and energy in thinking through the implications of doing research in a terrorism area. It is very complex, it can be dangerous, and definitely requires a lot of planning. So I jotted down some notes to go over with you, and it wouldn't be a bad idea to take some notes of your own. I'll also send some of these notes in a highlight announcement for class. So I wanted to start with, how do we deal with confidentiality as a researcher when a research participant is a known criminal or a known terrorist and may disclose criminal activity like terrorism or terrorism planning in your research? Do you have a duty to report? And this question came up quite a bit in different projects that students submitted. So essentially, terrorism research is conducted in a complex social context with many stakeholders, both national and international. And as you can imagine, the implications are huge. Research on terrorism can potentially present a number of harms to subjects as well as to researchers themselves. Most seasoned terrorism researchers argue against treating research on terrorism as some kind of exceptional case that requires new regulations, but rather to adhere to existing procedures and protections amongst a national dialogue in extreme cases of imminent threat and harm. So we tend to fall back on protections we normally use in the course of research, but again, with some nuances of national security to keep in mind. So as you can imagine, this is often an ethical dilemma for researchers, but it's nothing new to those that study criminology. You can use a certificate of confidentiality, also known as a COC, as a researcher. So according to federal law, the Public Health Service Act, Section 301, 42 USC, and 241, researchers who obtain a certificate of confidentiality may not be compelled by any federal, state, or local civil, criminal, or other legal proceeding to disclose the names or other identifying characteristics of research participants. This has been challenged in court, but not very often. So certificates are essentially issued by National Institute of Health and other units of the U.S. Department of Health and Human Services for the most part, for studies that collect sensitive information. You can also try to partner with places like the Department of Justice too. But essentially, it shields against the forced disclosure of identifying data. Certificates are intended to facilitate research by reassuring prospective participants about the security of their information and thus allow research to proceed on sensitive topics that are critical to the public's health and safety. So the full legal effect of a certificate is kind of unclear, but IRBs, and as you may recall, that stands for Institutional Review Board, which is basically a panel of researchers that are there to review the research design and plans to make sure that human subjects are protected and that ethical boundaries aren't crossed and that safeguards are in place. So an IRB will typically use something like a COC, a Certificate of Confidentiality, about 50% of the time or more when the behavior or topic includes alcohol and drugs, illegal behavior, and or damaging or stigmatizing behavior. So certificates protect behaviors which, if made public or made available to legal authorities, might result in the research subjects being arrested or at least investigated. So again, this puts the researcher in a compromising position, feeling compelled to report as information is disclosed by a participant. It may not always hold up to court subpoena, though. So if the courts, and in this case the Patriot Act, is invoked, or national security or imminent threat, then you could be in jeopardy. So remember, when you get subpoenaed by a court, a subpoena is a writ from a court to compel testimony or produce evidence, or face punishment if you refuse to. It comes from Latin for sub, meaning under, and pena, meaning penalty. So in the course of study, much of what people are telling you constitutes illegal activity if you're studying terrorism. And many of you in your assignments said, I want to interview a terrorist. And I'm sure that would be fascinating, but of course there are dangers and harms that could befall both of you. So if a district attorney subpoenaed your research files, these participants are under real risk. regardless of a researcher's perspective into whether they should or shouldn't go to jail, or if they're a good or bad person. Remember, as a researcher, we remain objective. All that aside, they certainly shouldn't do so because they participated in your research and they put themselves in legal peril. So there are several factors to consider when determining the need for a certificate of confidentiality. The first is a foreseeable risk of litigation. If there wasn't any risk of subpoena, then we really wouldn't even require the certificate in the first place. So regardless of the data, we wouldn't insist on it. If there's no legal issue, then obviously it's not relevant. So if there is a foreseeable risk of litigation or challenge in court, then of course you would consider that before getting a certificate of confidentiality. Essentially, it's a shield law for researchers, just like we have shield laws for journalists. Number two, is there a realistic threat of serious harm? It has to be a serious matter and not just a vague possibility that it would be disclosed. And third, the availability of the information elsewhere. Is there anything that would be in your records that we could use for purposes of research, investigation, or whatnot? And if there is, there's an alternative source of material, then why would we require a certificate when the subpoena could just be subpoenaed on the record rather than your research? So if you can get the information someplace else, you're fine. So because certificates of confidentiality have rarely been challenged in court, it is uncertain the level of protection that these certificates can actually afford. So obviously, in the unhappy circumstance that one would be successfully challenged, there's a huge con to both the subjects and the researchers of having this disclosure happen. For many research institutions, certificates have never been overturned in a court, and so there's some strong evidence anecdotally that the protection would hold up. However, it's unclear at what level. It also helps support certificates as a means to promote research participation if you can assure someone that their information is confidential, giving much needed reassurance to a prospective participant. But however, there are some legal experts and research administrators that are concerned that a certificate of confidentiality provides a false sense of security to a researcher. Now, this last part may be the nail in the coffin in terms of terrorism research. So, potential threats. First, in criminal cases, the grounds for challenging a certificate of confidentiality may be found in the criminal defendant's rights to collect evidence and prepare a defense. So those two rights would be placed against each other, the need for confidentiality and the need to prepare a defense. Second, a grand jury, which are largely secret and not open to the public, may have grounds to subpoena research data protected by a certificate. Third, rights to discovery may pose a threat to certificates in civil suits, non-criminal action. Fourth, narrow statutory interpretation is a concern in any type of legal challenge to certificates as far as how far they extend protections. And fifth, and this is probably the most important, challengers may argue that newer statutes, such as the Patriot Act, may be invoked and supersede or modify the statutory grounds for certificates. In the name of imminent threat and national security, we have sweeping powers under the Patriot Act. We're going to cover this even more later on in the class. So I'll attach an article to this information later in the email that I send. If you want an even deeper dive on the subject of protecting research that is terrorism research, I have some really great articles from a series of law reviews at different universities. But I thought you'd appreciate some of these ideas as we just covered this recently in class. So if you have further questions, feel free to reach out to me. And I was also in communication with some of our other faculty on the law side of criminology and law, and they agree with everything that I had put forward as far as what the foreseeable risks are and where it stands in court benchmark cases and so forth. So we've had a lot of dialogue on this. So again, reach out if you have questions. And it again shows you it's very hard to do solid terrorism research. I know I'm very grateful for the researchers that assumed the risks of some of the studies that we're reading in class to get that information out into the public. So I will see you next time, but again, reach out if you have questions. Bye-bye.